Hello everyone, I'm Anuj Nakade and you're watching LiveLaw. This video is about Section 124A of the Indian Penal Code. Section 124A of the Indian Penal Code has quite consistently been in the Indian news for being controversial in the same breath as Unlawful Activities Prevention Act of 1967. The Sedition law criminalizes the conduct of a person who brings hatred, contempt, or excitation of disaffection towards the government established in India. At least that's what it says here in the reading of the section. The controversy is unequivocally clear. There is a concern that the law can be misused to stifle dissent and use the machinery of the state to punish individuals critical of the policies of the government by painting them as inciting disaffection against the government. While there are legitimate concerns to national security which can be tackled by invoking the powers given to the state under these laws, it is not without the risk of unnecessarily infringing on individual rights. The law and the controversy occupied more of the news after several proceedings were started against dissenters and prominent individuals in the country for protesting against the Citizenship Amendment Act or the CAA in 2019. One of the persons involved in the protests against CAA was the RTI activist turned MLA from Assam and peasant leader Akhil Gogoi. He was arrested in December 2019 during the protests and was booked under various sections of the Indian Penal Code and the Unlawful Activities Prevention Act. The allegations against him were that Akhil Gogoi, as the leader of the Krishak Mukti Sangram Samiti, conspired with 3 other people to commit terrorist acts with a banned terrorist organization and mobilize the public to cause economic blockades and to paralyze the government machinery. In 2021, he contested and won assembly elections even while still in jail and secured his seat in the Assam State Legislative Assembly from Sibsagar. After 1.5 years of being detained, a Special National Investigation Agency or NIA court discharged him in July of 2021 on the grounds that there was no material on record to frame charges against him for his alleged role in anti-CAA agitations. However, the NIA filed an appeal against the special court's discharge order in the Gauhati High Court. The High Court remanded the matter back to the trial court for fresh hearing of charges against all accused, including Akhil Gogoi, in February of 2023. While doing so, the court observed that the special judge of the NIA court travelled beyond the level of shifting of evidence which is permissible at the stage of framing charges and instead considered the materials produced by the prosecution to determine the question of guilt. And the same was not permissible in law. MLA Akhil Gogoi then approached the Supreme Court with an appeal against the order of the Gauhati High Court. His argument before the Supreme Court was that the High Court had failed to examine if even a prima facie case was made out in the matter before overturning the special court's verdict. The Supreme Court, however, confirmed the order of the Gauhati High Court, setting aside the discharge order of the special NIA court in all aspects. The Supreme Court, however, in its order held that Akhil Gogoi is entitled to be protected against arrest, considering that if only the offences alleged against him under the Indian Penal Code are considered, he has served as an under-trial prisoner for more than half the maximum period of imprisonment. Now, Mr. Gogoi has filed a writ petition in the Supreme Court challenging the very constitutional validity of Section 124A of the Indian Penal Code along with other provisions which employ a similar logic of sedition inasmuch as they entail the same ingredients. His petition states that the allegations against him in the sedition and the UAPA case are speech offences. There have been no allegations of violence of any kind. The most severe allegations against him of conspiring to mobilize the masses in 2008 or 2009 and the criticism of government policies, specifically CAA. It is worth noting that the Gauhati High Court order we previously discussed produces witness testimonies implicating Akhil Gogoi as a conspirator with the banned terrorist group that has incidents from 2008 and 2009 as allegations of sedition against him. The petition also relies on an order by the Supreme Court in 2022, where the Supreme Court directed the colonial era law of sedition under Section 124A to be effectively kept in abeyance until the Union government had reconsidered this provision. The court's order reads, and I quote, "All pending trials, appeals and proceedings with respect to the charge framed under Section 124A of IPC be kept in abeyance. Adjudication with respect to other sections, if any, could proceed if the courts are of the opinion that no prejudice would be caused to the accused." The court in this order had noted that the case made by the petitioners in the 2022 order, saying that the law dates back to 1898 and predates the Constitution itself and is being misused, and also noted some instances of glaring misuse of the provision cited to them by the Attorney General at the time. The argument in this petition is that not only is the law stating of offense of sedition, but the very logic of what sedition is under the law is, I quote, "vulnerable to judicial review." That's all we have for you in this video. If you found it informative, please leave a like and tell us in the comments how we can shape our content to bring you your legal news in more engaging ways. If you've been watching our content for a while and find it reliable, credible and unbiased, please consider supporting us through the YouTube membership program at the cost of just ₹89 per month. You can also donate an amount of your choice through the thanks button on YouTube. Don't forget to subscribe to our channel and hit the bell icon for notifications. Thank you.